51, Your Worship, running from page 51 to 62.
Yes.
Now, so it is an asset purchase agreement.
Yes, sir.
Okay, just for interest sake, who led the drafting of this agreement? Is it Enercon or NAMCOR? Who generated the document?
Since NAMCOR was the company that offered, and they also did it's them who did the evaluation of the asset, they led in drafting this agreement.
So does
What
that
is your
mean that
answer? Just a minute. What is your answer to the question that who drafted
NAMCOR.
the agreement?
Yes.
Yes, we can proceed.
Now, that is very interesting, particularly in respect of fraud charge. And now, go to page 62 before we go to the agreement. You start at page 61. I see that you have signed, both you and accused number 6 have signed on behalf of the company, your company.
Yes.
And that was on the?
On the 15th day of July 2022.
Okay. Then at page 62,
Immanuel Mulunga, the managing director.
okay. So he signed on the 18th of July 2022.
Yes, sir.
Okay. Now, if you can look, Your Worship, if you can go back to charge 34, count 34, count 34, which you find Mr. Elindi at page 1, which was originally numbered as 56. Are you there?
Yes, I'm here.
Now, this charge suggests apparently fraud was committed on the 15th of July 2022. You see,
Yes.
in the first paragraph.
Yes.
If I understand, it's difficult to understand the state, but if I understand the state, that date is taken from the date you signed. If you go to page 61.
Yes.
Page 61, what is the date at page 61 that the representative of your company signed?
The 15th of July 2022.
Okay. Now, just go back to page 1 of the bundle again, count 34.
Yes.
You will see that in an alternative, the state is saying that, talking about theft by false pretenses. You see that?
Yes.
Again, if you can read that charge before we go to the agreement, the alternative one, theft by false pretenses. Just read it.
In that upon or about the 19th of July 2022, and that or near Windhoek, in the district of Windhoek, the said accused did unlawfully and with intent to defraud or to steal, misrepresent to NAMCOR that he was allowed to sell 19 service stations to NAMCOR while he was not in a position to do so, and said assets were encumbered to the Ministry of Defense and Veteran Affairs due to a 15-year agreement signed on 15 September 2016, and did by means of the said misrepresentation obtained from NAMCOR money in the amount of 53,212,000, whereas the said accused, when he so pretended, as aforesaid, well knew that he was not entitled to receive the money for his own use, and benefit, and thus the accused did commit the crime of theft by false pretense.
Okay, first of all, let's clear up some things. I see this charge is directed at you in personal, individual capacity. Is that correct?
Yes.
But now, again, just for record, who actually entered into the agreement with the agreement consent with NAMCOR?
Enercon Namibia.
A corporate entity.
Yes, sir.
In what capacity did you sign the agreement?
I acted on behalf, in my capacity as director and also chairperson of the company.
Okay, but in commercial sense, and anybody with a small knowledge of law and commerce, who is the party to that agreement? Who are the parties?
Enercon Namibia and NAMCOR.
Were you a party to that agreement?
No.
Okay. Secondly,
individually, no.
Okay. Secondly, the people who were representing NAMCOR, this charge says that you made misrepresentation to them. In other words, you misled them. The people who were representing NAMCOR, including the MD, Mr. Mulunga, did they ever accuse you of fraud?
No.
Did anybody complain that, look, you gave me information that is misleading and fraudulent? I would not have signed this agreement if I knew this information. Did Mr. Mulunga and others ever accuse you of fraud?
Not at all, because in first place, those assets that we are talking about were built with the resources of Enercon.
Just slow down.
You say
No, yes, what is the point you are making? I want to understand. You are saying those resources, the assets were built with the resources of Enercon.
That's why no one would accuse me of wrongdoing, Your Worship.
okay, you have already testified that it was actually NAMCOR who offered,
Yes.
not the other way.
No.
Did you instigate them? Was it up to you? Is it your business to block them from not offering to buy your interest, title, and right into the assets?
Not at all, because it's in commercial transaction, any entity, I believe NAMCOR, saw the potential to buy those assets in terms of title and interest instead of building it from the scratch.
Okay, now before we go back to the agreement, let's clear up this. The charge says that you misrepresented to NAMCOR that he was, probably referring to you, was allowed to sell 9 service stations to NAMCOR. What do you say about that?
I did not misrepresent to NAMCOR. The thing is, NAMCOR went to the service station, verified that those facilities existed, and consciously took the decision to offer Enercon to purchase those assets.
Just slow down.
I don't see how I could make a misrepresentation in that case.
Speak up, please.
No, I'm saying I just don't understand how I could make a misrepresentation in that instance.
Okay. Another allegation appeared to be that you were not in a position to sell the right, of course, title and interest in those assets. What do you say that?
It was up to my company, as NAMCOR was taking up the exclusive supply. I had the right to sell those assets.
Just pause.
You see, you are selling something that you are conscious
When I
of.
say pause, you just pause and wait, and then I indicate you can proceed.
Apology, Your Worship.
Yes, you can proceed.
Yes.
Yeah. Since I was conscious and truthful that the assets in question were built with the resources of Enercon, I would not have asked anyone other than my company and the board to have those assets to alienate. I mean to enter into that agreement.
Maybe the state is. Both you and Mr. Elindi, Malakia, signed the agreement on behalf of Enercon.
Yes.
Maybe the state is confused. Were you supposed to get permission from any other person apart from yourself as the directors of the company?
Not at all.
And you earlier stated that the Ministry of Defense knew about what was going on. What you said it was in their interest. Just clarify. What did you say?
Yeah, it was in the interest of the Ministry of Defense for us to have sufficient fuel and the facility, especially when fuel prices were going up substantially, for us to have a stronger entity like the state-owned company such as NAMCOR supplying and also keeping part of the fuel in a reserve, which we didn't have as Enercon.
Okay. Okay, now let's then go to the agreement which appeared to have been the cause of all this celebrated case, we are told. Go to page 51. You have already identified that agreement. At page 51?
Yes, sir. Yes, sir.
And first of all, somewhere the state appeared to suggest something about unauthorized transaction on part of the NAMCOR. Can you just read the first paragraph relating to NAMCOR? Asset purchase agreement between, can you read what is next for court?
Between NAMCOR Petroleum Trading and Distribution Pty Limited, a company registered in Namibia and incorporated in terms of the laws of the Republic of Namibia with registration number 2000/421, herein represented by Mr. Immanuel Mulunga in his capacity as the Managing Director, jury authorized there.
Oh, okay. Let's stop there. Jury authorized. Now, the agreement indicates that Mr. Mulunga was jury authorized. Was it your business to go around behind him and the agreement they drafted at NAMCOR to check whether there is any problem? I'm not saying he was not authorized. Or I'm saying, was it your duty or responsibility to go around and sniff around whether or not the management was authorized?
Not at all, sir.
Okay. Let's move to then page 52. Now, can you just read the first paragraph in first paragraph under witness?
Whereas NAMCOR Trading and Enercon entered into a certain letter of intent to purchase asset dated 8 July 2022 and attached here to as Exhibit A.
Okay, just hang on. If you can go to page 63.
I'm there, sir.
What is that page 63? Identify again. You dealt with that, but for record, just identify it.
Offer to acquire Enercon Namibia Pty Limited petroleum assets.
So that is the offer made
by
NAMCOR to you.
To Enercon.
Okay. And it's dated the 8th of July 2022.
Yes, sir.
So that is the letter being incorporated in the agreement. In other words, to take the relationship from the 8th of July to make it part of the agreement.
Yes,
that
sir.
offer, to make
Yes.
it and incorporate it into the agreement.
Yes, sir.
Okay? Now, then it says, read the next paragraph.
Whereas Enercon is the owner of certain bulk storage facility comprising those assets and any and all equipment used by Enercon in conjunction with the operation of the said asset set forth in Exhibit B, attached hereto, hereinafter referred to as the assets.
Okay, I'll come to that. But the asset being spoken about, bulk storage facilities, what is that again, just for record?
It refers to the home-based service station, fuel stations, that
Okay.
we, Enercon, build inside the military facilities.
Is that the same asset you said you were supposed, in terms of the agreement of 2013,
Yes,
you
sir.
were supposed to build it with your own funds at
Yes.
43 million, but you ended up spending 58 million.
Yes, sir.
Is that the asset?
Those are the assets I'm referring to.
Okay. Now, without wasting time, let me maybe just to, was the money that you used to build, were you assisted by NAMCOR or government to build the infrastructure?
No, not at all. Part of the money we raised through Development Bank and other corporate entities. And that money also carry financial burden and interest.
Okay. Now, there is an important sentence so that there is context to this whole thing. Can you read paragraph 1 and 1.1, first sentence? At page 52, your worship.
Purchase and sale of assets, purchase and sale on and subject to the terms and conditions of this agreement. NAMCOR Trading agreed to purchase from Enercon, and Enercon agrees to sell and transfer to NAMCOR Trading all of Enercon's right, title, and interest in and to the assets.
Okay. Now, this agreement, whoever drafted, actually drafted very well. There is a usage of the words, just mind my language, agrees to sell and transfer to NAMCOR Trading all of Enercon's right. That's one. Is that correct?
Yes.
That's one, right.
Yes.
Number 2, title.
Yes.
And number 3, interest.
Yes.
And then 2 important words. One is in. Is that correct?
Yes.
And then 2, the asset. Is that correct?
Yes.
So therefore, is it then correct that what you sold is the right, title, and interest in and to the assets? We are going to the list.
Yes.
Okay. And those are the assets you built with your own funds.
Yes, sir.
Are those assets also then what you explained this morning different from the fuel management system?
Yes, they are different from the fuel management system, and these assets are in the oil industry. Any oil company that built the assets, the title and the right belongs to that company that built the assets.
Just pause.
You are saying?
Just pause. Now, if I understand you correctly, just for clarity, You are saying the company that built retains the title to those assets.
Yes.
Now,
Yes,
which
sir.
yes, which assets did you build in this case?
We built the pumps, tanks, all the underground connection, mini canopy, and petrol attendant house.
And you remained the owner of these assets.
Until the end, until 2031.
2031.
2031. Yes. And I'll maybe, Your Worship, extend, even if the Ministry of Defense was to cancel this agreement, they would reimburse Enercon for those assets.
May I proceed?
You can proceed.
Yeah, just because of the question again, maybe we didn't make it clear. Let's go back to page 102 of the record. Earlier, you, in an attempt to say which asset you built with your own money, I took you to page 102. Is that correct? Are you there, sir?
Yes.
Give him time, he's getting there.
Yes, I'm there now.
And that is part of the 2013 agreement.
Yes.
If you look at page 100.
Yes, sir.
Yeah, so that is the agreement after the 2012. Now, go to page 102.
Yes, I'm there.
Now, again, just for the record, exactly as to what those assets you built, can you just read out that paragraph from site remediation? What does that mean and what does it include? Can you just read it?
One
At the bottom,
at the bottom.
What paragraph?
3.1, your, yes, page 102.
I will start site addition of Article 2 bis.
Yes.
It's a MOD refueling site shall mean the MOD.
Are you reading 3.6?
Is it 102?
Yes.
Are we at 102?
At the bottom 6, paragraph 6?
Oh, paragraph 6.
Yes.
Add new sub-article 3.1 bis site remediation and civil works
Yes.
by adding the obligation on the part of DPF, which is Enercon, to site remediation shall include
Okay.
all activities related to the removal of all underground fuel tanks,
Yes.
procurement and installation of new composite underground tanks
Yes.
on all sites. This includes installation of suction pumps and automatic tank gauging equipment.
Yes. Now, and in the middle, the next paragraph, read the second sentence after 23,000 liters tanks.
It would appear that we have covered that aspect.
No,
if there's something you want to
No,
clarify.
Your
yes.
Worship, I think with respect to the court, I just went to that paragraph because of the court asking my client which asset did you build. I earlier took the court to this so that my client place it on record. I will just clarify it because
Okay.
when I realized that there
That's
are
why I'm saying if there's something you want to clarify, you are free to go.
No.
That is my point.
Yes.
Yes.
Okay, may I just complete what I'm doing, Your
Yes,
Worship?
you can proceed.
Yes, can you start with the fourth line, which says
MOD refueling site, including installation of a fixed line network infrastructure on all home-based
Okay.
basis.
Okay, now, can you just go back to 102 to finish this clarification? The word procurement, it says all activity relating to the removal of old underground fuel tanks, procurement and installation of new, then it says tank. What is procurement?
Is to buy.
Okay, who was going to buy?
Enercon was going to buy.
With
those
whose
fuel
money?
With their own funds. With
Project-
our own funds.
Okay, projected to be around how much?
It was around 43 million.
And you spent, as you said already, around?
We reached about 58 million.
Thank you. And those are the assets
That
His
we-
Worship asked.
Yes, thank
Okay,
you.
thanks. Let's go back to page 52. Now, we have done with what you sold to NAMCOR, title right and interest in the assets. If we can move to paragraph 1.2. Just read out paragraph 1.2.
1.2 purchase price. NAMCOR Trading agrees to purchase the asset from Enercon for a purchase price of 53,212,000 Namibia dollar, inclusive of VAT, the purchase price. C2 asset valuation reports attached as Exhibit C. An amount of 35 million Namibia dollars of the purchase price shall be paid by NAMCOR Trading to Enercon by electronic transfer to Enercon's nominated account as follows.
Just say the account, that is very important.
The account name, Enercon Namibia Pty Limited, 2009/01100.
What bank is it?
Bank Windhoek,
Branch?
Capricorn Branch,
Say the account number on record.
is account number CHK 80235315520.
Okay,
It's a business check account.
just end there. That account ends with 520 at the end.
Yes.
That bank account.
Yes, sir.
Just mark that there's something important about it. Now, read then the next paragraph that starts with NAMCO's Executive Strategic Finance.
NAMCO's Executive Strategic Finance duly authorized on behalf of NAMCOR Trading to be a signatory to the above-mentioned account shall at all times remain a signatory to it.
Okay. Now, what does this mean? Does it mean, explain to court, does it mean that it's your account where the money was going to be paid, but then as a condition imposed by NAMCOR, one of their employees must be a signatory?
Maybe just let it open to him. What does it mean? So
Yeah,
maybe he can
yes.
take it.
Yeah, yes.
What this means,
Yes.
Your Worship, is that this account, NAMCO's Executive of Finance had the primary signatory power on the account, but co-signing with Enercon.
Okay. And you agreed to this?
Yes,
Was it done?
yes.
Okay. Now,
Why was that done? What was the need or what was the reason? The
It-
rationale
it's
behind
just to
that?
create transparency. And also ensuring that all the parties are happy with the process.
okay, but I think for the court to explain to the court in relation to what, go back on top of the account, that last sentence under paragraph 1.2. Can you just read it again?
An amount of 35 million
Yes.
Namibia dollars of the purchase price shall be paid by NAMCOR Trading to Enercon by electronic transfer to Enercon's nominated account.
Okay. I just want to ask, 35 million of the 53 million were to be paid in the account where NAMCOR has a representative. Is
Yes.
that what it means?
Yes.
Okay. Let's then proceed for context with the next sentence just before another account at the bottom. The balance of the purchase price?
The balance of the purchase price in their sum of 18,212 Namibia dollars shall be electronically transferred to Enercon's nominated account as follows. Account name, Enercon Namibia Pty Limited 2009
Yes.
stroke 011
The bank.
Bank Windhoek Capricorn branch, and the account number was 8003510,848.
Okay, now just for clarity, this account ends with 848. Is that correct?
Yes.
So is it different from the first account where NAMCOR's executive for strategic finance should be a signatory?
Yes, sir.
So it's different.
It's different.
So the first account ends with 520 and the
Last one.
last
with
one ends with 848.
Yes, sir.
But they are both at Bank Windhoek, both in the name of your company. Is that correct?
Yes, and in Capricorn branch.
Okay. Let's move to the next page then. Can you read the next sentence which starts with NAMCOR Trading at page 54?
NAMCOR Trading shall not transfer the purchase price to Enercon's nominated bank account until Enercon provides to NAMCOR Trading proof of ownership of the assets.
Okay, this is very, very important. Now, the term of the agreement is that you said at the beginning NAMCOR drafted the agreement.
Yes.
So it built in a safety measure that it will not transfer its money unless proof of asset is provided.
Yes.
Okay? And then read out the next sentence.
Within 1 business day from the date when the sum of 35 million Namibia dollar reflects in the Enercon's bank account stated here under Enercon, Enercon agrees and warrants that Enercon shall transfer a sum of 35 million Namibia dollar free of charges to NAMCOR Trading bank account below, which was now NAMCOR Petroleum Trading and Distribution Pty Limited, Bank Windhoek, Windhoek branch, account number 8000158,325,
Okay.
business check account.
Okay,
Can
just
you just explain what that means? Just that aspect.
Yeah, it means Enercon, upon receiving the amount of 35 million that was sent to the joint account, that amount of 35 was transferred back to an account owned by on account of NAMCOR Trading, just to cover all other expenses that we have incurred for fuel supplied already to Enercon.
I'm coming to that.
Okay.
Can you just read out the next sentence at the bottom of the account number of NAMCOR?
Okay. In respect of a debt owed to NAMCOR Trading by Enercon for petroleum products supplied to Enercon by NAMCOR Trading.
Okay, just hang on there. The
Just pause.
may I proceed?
Yes, you can proceed.
Just for clarity and context, the 53 million you said is purchase price for right, title, and interest in the asset.
Yes, sir.
Okay? Then 35 million is paid in a nominated account where NAMCOR executive, one of NAMCOR executive is a signatory. Is that correct?
Yes, sir.
Now, what you have just read out now is it says that is for debt owed to NAMCOR. Does it mean to say on the date your company received part of the 53 million,
Yes.
you owe owed certain debts to NAMCOR, and it was agreed that...
That is why I've asked him to clarify. That was my question.
It may be enough
Yes.
for your worship, for your clarification, but it may not be enough for me to build my client case to show that the state case is enough. Your purpose for questioning is different from my purpose, your worship. Because I will be asked question, whenever I'm going to make arguments at the end, I must make those arguments in respect of matters where I led my client. I have a specific reason why I'm doing that. And because I need to show, as we committed ourselves, that with greatest respect, this is a commercial case, it's not a criminal matter. I think with respect, the court must allow me to deal with my case in the manner that I feel it's beneficial to my client.
Yes, I understand, Mr. Namanja, but he is under oath. That aspect you are dealing with, that explanation, did not directly come from him. That is why I've asked
Which part
for
did
him
not come
to clarify.
Which part did not come?
About the 35 million that he owed. They owed the money to me to...
He just read it. He said in respect. This in respect he's referring, he just said it.
That is why I'm saying I asked him, can you clarify what that means?
But your worship, what if you understood and I didn't understand? I am the lead person for the client. I must lead my client so that it is very clear what I want to do. So in any way I was gone, it's becoming very difficult, your worship. The court has the right to ask my client for clarification, perhaps for everybody, and in some cases for the court itself. But I also have a right, me as the legal practitioner for my client, to ensure that I properly understand my client. So what I was trying to, may I ask the last question so that I get what I want from the client?
You can proceed.
Yes. Mr. Elindi, what I'm trying to say is that, does it mean, as a fact, rather let me ask that, did Enercon owe NAMCOR money by the date on which the 35 million was paid in the joint account?
Yes, sir. And that's why that NAMCOR paid back that amount of 35 million to NAMCOR. I mean, Enercon paid that amount.
Just pause for court. Court is writing down.
Yes, you can proceed.
Now, did your company comply with this obligation?
Yes,
under this program?
Yes, we immediately transferred that amount back to NAMCOR.
The 35
The
million?
35 million.
Just pause.
Yes, I proceed, your
Proceed.
Your worship.
Yeah.
Then, can you just read the next sentence, starting with failure? There is at page 54, the next sentence.
Yes. Furthermore...
No.
Yeah?
After you start at the bottom of the account of NAMCOR, you started with a sentence that starts in respect of a debt. You see that?
Yes.
The next sentence, read the next sentence.
Furthermore, said NAMCOR Trading furthermore reserve the right.
Is that?
That way.
Start with the word failure, Mr. Elindi. Failure in the second sentence.
Oh, okay.
Just give him time. He's not, it looks like he's not. Mr. Namanja, can you just assist him maybe?
Okay.
No, yeah, I got it.
You get
Failure by Enercon to comply with this clause.
Okay,
the NAMCOR.
just
Yes.
hold on there. What is this clause? Let's just go for context. We are coming from, go back to page 53. What is that clause that deals with, gives all this account? What is that clause, that article, what is it? Look at page 53 and look at on the left-hand side. There's a number.
The number 1.2?
Yes. Okay. Let's go on. That clause goes over to page 54. Is that correct?
Yes.
So reference to failure by Enercon to comply with this clause, what clause is being referred to?
Is 1.2.
Exactly. Yes, go on then.
Okay.
Go on.
Failure by Enercon to comply with this clause, the NAMCOR signatory to the Enercon bank account under 1.2 shall under no circumstances sign off the release of the sum of 35 million to any other account but to NAMCOR Trading. NAMCOR Trading furthermore reserve the right to institute legal action and any other action in law to assert its rights herein. All legal costs for this action shall be for Enercon's account.
Yes, now, unfortunately, we are now in a criminal court. Now, first of all, did the representative of NAMCOR on your account, did she ensure that the amount is paid to NAMCOR towards your settlement of your debt?
Yes, she did.
Okay. If you did not do it, what does the agreement say? You just read it. What would have NAMCOR?
The representative of NAMCOR would have refused to allow the transaction.
Okay. And the agreement further said, what does it say in respect of legal action? If you
And NAMCOR further would have taken legal action against Enercon.
Okay.
And
In relation to
in
that?
relation to the transfer of that 35 million.
Yes. Now, did NAMCOR, in respect of that amount, 35 million, ever go to court complaining it's fraud or whatever?
Not at all.
Okay, and then read the next sentence, the last one.
The
We were starting with all legal costs.
all legal costs for this action shall be for Enercon, Enercon's account.
Okay, that is now, does it mean that if they take you to
If
court?
they take us to court, which they didn't, because we complied.
Okay. Now, then there is an effective date. I do not want to waste the time, court's time. And I want to take you to the asset register. I'll come back to that agreement later on. If you can go to page 76. Identify the document at page 76. What is that document?
This is the document addressed to the Managing Director, NAMCOR Petroleum Trading, from our the Ducactus, our financial accountant.
Okay, first of all, what is Ducactus?
Is our financial accountant.
Accountant of the company?
Of Enercon. Is the financial accountant of Enercon.
Okay, and who signed that document on behalf of that the accountant?
It's the partner or the member
Of
that particular Ducactus.
Say the name.
Jan Ole Dera.
So that is an accountant.
Yes.
It's writing to who?
Writing to the Managing Director of NAMCOR Petroleum Trading and Distribution Pty Limited.
On what date was it?
15th of July 2022.
Is that the date you signed the purchase agreement?
Yes, sir.
Okay, can you read out the content?
The letter said, dear sir.
Just listen, Mr. Until I finish.
Okay.
Can you just read out the content of what the accountant to your company is saying to NAMCOR?
Can I start with the title?
Yes, yes, sir.
Enercon Asset Register for MODVA, Petroleum Products Storage Facility and Related Installations.
What is MODVA?
Ministry of Defense and Veteran Affairs.
Okay, then go on.
Reference to the above matter, we confirm that we are the internal accounting firm for Enercon Namibia, Pty Limited. We also confirm the correctness of the Enercon Asset Register in respect of Enercon MODVA Petroleum Products Storage Facility and related installation per Annexure A here to attach based on Enercon inventory.
And is
Yours
it cited?
faithfully, Jan Ole Dera.
Okay, now just to ask, these are accountant saying they are confirming what are they confirming?
The correctness.
The correctness of what?
Of the asset that, the correctness of Enercon Asset Register.
In respect,
In respect of Enercon MODVA Petroleum Product Storage.
Okay. Did you ever, just for interest's sake, this, not the company, but its accountant, did you hear at the time of your arrest in the media or prior to this, your arrest, any allegation saying that the accountant made fraudulent misrepresentation to NAMCOR?
Not at all.
On behalf of your company?
Not at all. We haven't.
Did the NAMCOR question the auditor's correctness of the authenticity and correctness and sincerity of the verification by accountant?
Not at all.
But anyway, can you just answer this question? Did ACC call you in to explain and give them all this information before they arrest you so recklessly? Did they ever give you an opportunity to go through this document and explain this simple thing to them?
No, they didn't. We waited, and no one came to us other than the time they started calling and telling us we have to. They are coming to arrest us.
Let me just ask you. You forget about your brother and his wife.
Yes.
This is very disturbing. Are you saying before the date you were arrested, ACC never sent you questions, never asked you to explain, to provide documents and understand this at all?
Not at all.
Okay. Let's go to page 77.
Yes.
It says Enercon Namibia Asset Register. Can you just read it out?
Yes. I have the descriptions there. There is one 25 cubic tank, 245 cubic tank, 385 cubic tank, 2 horsepower STD.
What page are you at?
Is it? Oh, sorry. Is it 78?
77.
Oh, 77 Enercon Asset Register, Fuel Storage Facility and Installation, MODVA site.
Okay. That is the description of the document at page 77.
Yes, yes.
And what is at the bottom? Just read it.
Ducactus Financial Consultant, CC.
Okay, and their addresses.
Yes.
I want to ask you, because the allegations of fraud are directed at you, I want to ask you two important things. You said you signed the agreement together with your brother on behalf of Enercon on the 15. Go to page 61. Your worship, page 61.
Yes, I'm here.
Now, on that date, what did you do there at that page?
I don't get your...
On the 15th?
We signed this agreement.
Okay, so you signed.
Yes.
On behalf of?
On behalf of Enercon Namibia.
Okay, that was on the 15th of July.
Yes, yes, sir.
Remember you told us that the agreement stated that NAMCOR will not pay until correctness of the assets has been verified. Somewhere you took the court in the agreement.
Yes, sir.
Okay. Then that is on the 15th. You signed.
Yes.
Who verified or informed NAMCOR of the correctness of the register? Go to page 76.
Yeah, that is now.
On the same day that you signed.
Yes, that is now our internal financial accounting.
Okay. If that is correct, is it correct for me then to correct me if I'm wrong? On the 15th, in relation to the implementation, director signed and the accountants, they verified and informed NAMCOR of the correctness of the register of the subject of the sale. Is that correct?
Yes, sir.
On the same day.
Yes, sir.
Yours was to sign.
Yes.
Then, let's go to page 78. I just want to verify with you. Maybe you can read out only 2 or 3 at page 78. Just read out 3 in the interest of time.
1
Yes.
25 cubic tank,
Yes.
2 45 cubic tank,
Yes.
2 horsepower STP.
Okay, that's fine in that block. Go to the next column at the bottom there. Read out 2 or 3.
Yeah, 1 25 cubic tank, 45 cubic tank, 2 horsepower STP.
Okay, go to the next page. In the interest of time, 79.
The same 1 25 cubic tank,
Okay.
pumps, transport.
Okay. Go to page 80. Read out some. 2 or 3.
25 cubic tank, 45 cubic tank.
Okay. Go to page 81.
25 cubic tank, 45 cubic tank.
Okay.
Yes.
Go to page 82.
25 cubic tank, 45 cubic tank.
Okay. It's enough. Now, I want your confirmation. This asset, this infrastructure, including tanks and pumps, you read out.
Yes.
Who bought them? I'm not talking about in 2022. Who acquired them and installed them at MDF?
For all the home-based service station, all those pumps and tanks were purchased and bought by Enercon Namibia.
Okay. And who has the right, title, and interest in those assets up to 2031?
Enercon Namibia Pty Limited.
Who exploit the benefits? In other words, when you do business in those tanks or through those tanks and supply oil, who exploit the benefit, profit, and so forth?
It's Enercon Namibia.
Okay, were you prohibited from sharing your title right and interest and give opportunity to someone else? Were you prohibited?
Not at all.
By law or by any agreement?
Not at all. Not in the agreements we have.
So now,
because in any event, the next entity would have just done the same thing we were doing, supplying, maintenance of all the pumps and tanks, and guaranteeing that all environmental issues are taken care of.
and conducting business?
And making money out of it, profit, of course.
Okay. Now, before we went for lunch, I want to return to that question now. It appeared to be a lucrative business opportunity, and there shouldn't be shame about it. Now, did you consider as a business, the remaining 9 years, you said when His Worship asked you, you said you were not in a position to say how much you would have made in terms of recouping. Are you in a position to say now?
More or less, yes, because if you look at the dealer margin,
Yes.
which was now 0.56 liters, cents per liter.
Which year?
In the year that we signed, which was
Signed with who?
with the Ministry of Defense.
Okay. That 2012 and 13?
Yes.
Okay.
The average liters that the ministry was pumping was close to 500, sometimes depending on the national days that are there or some important people pass on. It was about 500,000 liters, sometimes up to 700,000 liters. So if you multiply that, if you multiply that times 0.5 cents per liter times 12, the number of that could give you, for example, times 30 days times 12, which is per year, it will give you an indication of the amount.
But what you said, 500.
About 500,000 liters.
Oh, 500,000
liters to 700,000.
Is it per day or
per month?
Per month.
Per month.
Okay, and you said what do you mean when you say if important people pass away? What do you mean?
When you see, defense has got movement, and whenever, for example, there is an event like Independence, August 26 celebration, or any of the important people die when they have to do national official funerals and all that, the number of liters increase.
Oh, is this what you mean?
Yeah, in terms of spending.
Okay, so what you're
I'm trying now to say the liters varies sometimes from 500,000 to 700,000.
Okay. So in those circumstances, would you be able to tell us, to give a specific amount to court that you would have exactly made this for the remaining 9 months? Is it easy to get a specific amount?
Not completely.
Okay.
Not completely. But we would make money, apart from also the dealer margin that increased over a period.
Okay. But seeing that the dealer margin and its trends and fluctuation is a factor, NAMCOR, were they precluded during negotiation not to consider such factors? In any way, did you?
No, not at all, because they are in the industry and they understand. And that is what I say. In any event, they would make money. They were going to make money based on the number of years that remain.
The 9 years.
The 9 years.
Okay, now let's go back to the agreement and what's the page? The page again. Page 51. I'm being told, Your Worship, 51.
51.
Yes. Now, it's a saddening state of affair. We are in a criminal court. Can you move to page 58? Can you just read out paragraph 8.1? And yes, can you read it out?
8.1 arbitration, point 8, arbitration, 8.1, any dispute between the parties with respect to any matter.
Just hang on there. Who are the parties being referred to?
Enercon and NAMCOR.
So any dispute between them, is that what it says?
Yes.
Okay,
Yes, sir.
go on.
Any dispute between the parties with respect to any matters arising out of the current agreement or its interpretation or their respective rights and obligations under the current agreement or its cancellation or any matter arising out of its cancellation shall first be referred to executive management of the parties for resolution. In the event that the dispute cannot be resolved at that level within 14 days of such referral, it shall be submitted to and decided by arbitration in accordance with this clause.
Yeah, go to 8. It's 8.2 is very important.
8.2 says there shall be one arbitrator who shall be, if the issue is primarily an accounting matter, an independent chartered accountant, B, primarily a legal matter, a practicing senior counsel, or C, primarily a technical matter, a person with suitable technical knowledge.
Now, we now know the correctness of the register was not done by you, but by professional accountants. That's what you testified.
Yes, yes.
So partly it should be an accounting matter. It may also be legal. Now, did NAMCOR, it says any dispute, ever declare a dispute in relation to the fact allegation by some, including outsiders, that apparently you didn't have the right to sell the title, the assets are encumbered this way or that way? Did they come within this agreement?
No, not that I'm aware of. If it was done not at the time when I was a director of Enercon.
And you said you were director up to?
23rd of July, no, 23rd of February 2023.
Okay. Well, 2020?
23.
September, you said?
No. 23rd of February 2023.
Okay. That is almost, if the agreement was signed in July 2022, is about 8-9 months after that. Is that correct?
Yes. Yes, sir.
So you are not aware of any arbitration or a matter being referred to the executive management of the party for resolution?
No.
Now, but why so? Do you know why? You have, instead of an accountant, instead of a senior counsel, instead of a technical person, the magistrate is the one listening to this. Do you know why?
I don't know.
Okay. Now, there is an interesting and again shocking part of this. Go to page 188. Yes. I just want to ask you 188, right at the end. 188. You have earlier stated that you left the company, and who became directors of Enercon?
To the best of my recollection, it was Victor Malina, Austin Elindi, and Sharumbu. Ndajoina Sharumbu.
Who? Ndajoina Sharumbu. To the best of your recollection.
Yes. Okay,
so by September 2023, you were not a director?
Neither a shareholder of Enercon.
Okay. Now, I would identify the document at page 188. It's very important to show that really this is shocking why you are in criminal court. Just identify it.
The document has is from NAMCOR, 13 September 2023, and without, I believe this is without prejudice, but it's just without inquiry, inquiry Shiwana Ndeunyema, sndeunyema@namcor.com.na, Mr. Victor Malima, Enercon Namibia Pty Limited, without prejudice, come then here. It's a matter of how it was drafted. Windhoek, Namibia, dear Mr. Malima.
But just hang on for court. But does it say without prejudice? Where is prejudice?
Yeah, prejudice is now allocated here where where Victor Malima is.
Yeah. in the address. Okay, fine. It's not your letter. It's fine.
Okay.
So the letter is addressed to Malima.
Dear Mr. Malima.
Okay.
Cancellation of asset purchase agreement between Enercon Namibia Pty Limited, Enercon, and NAMCOR Petroleum Trading and Distribution Pty Limited, NAMCOR Trading.
Very important. Just hang on there. The date is 13 September 2023. You see that?
Yes, sir.
Okay, go to page 189 first. We'll come back to the content. Who is the person who signed on behalf of NAMCOR?
Shiwana Ndeunyema, Acting Managing Director.
Okay. And one thing, this letterhead say NAMCOR. Just go at the bottom at page 188. Can you read out that name of National Petroleum Company? Just read out that name.
He said, holder, NAMCOR Petroleum Trading and Distribution.
No. At the bottom on the right-hand side at page 188, just above number 1 Aviation Road, read out that name.
Aviation Road.
Do you know what?
National Petroleum Corporation of Namibia Pty Limited.
Okay. Read it slowly.
National Petroleum Corporation of Namibia Pty Limited.
Okay, now let's go back to page 51. And keep your other finger at that page 188. What is the company that Enercon entered into the agreement with? What is the company? Read it out.
NAMCOR Petroleum Trading and Distribution Pty Limited.
Okay, Pty Limited.
Pty Limited.
Mind my words, does it have a Pty?
Yes.
In bracket?
Yes.
Then does it have Ltd?
Yes, sir.
So it's a private company?
Yes, sir.
Okay, then let's go to the page 188.
Yes.
Read out the name again.
National Petroleum Corporation of Namibia Pty Limited.
Is that the same entity that entered into the agreement with?
It doesn't look like.
Okay. The other one you said is
We
NAMCOR
say
Petroleum Trading and Distribution
Distribution.
Pty Limited.
Yes.
The other one where Mr. Shiwana Ndeunyema is busy is National Petroleum Corporation of Namibia.
Yes.
Okay. What is he trying to do? Again, go back to the title of the letter.
Cancellation of asset purchase agreement between Enercon Namibia Pty Limited, Enercon, and NAMCOR Petroleum Trading and Distribution.
Okay. And he's speaking.
Pty Limited.
Okay. And he's speaking to Mr. Malima of Enercon.
Yes.
And read the first the content of the letter.
I sincerely hope that this letter finds you well.
Okay. Number 1.
NAMCOR Trading procured asset for storage of petroleum products from Enercon Pty Limited in 2022, which assets are situated at various Ministry of Defense sites.
Okay, just hang on there. So in this paragraph, he's recording that NAMCOR Trading procured assets for storage of petroleum products, and then he says they are at various sites, at various Ministry of Defense sites. Is that correct?
Yes, sir.
And what did you say the word procured means? Procured?
It's simply the rights.
No. When he say NAMCOR, earlier I asked you, what does procure mean? What did you
purchasing,
say?
I mean,
Okay.
yeah.
So purchasing. So does that mean then Mr. Ndeunyema is recording that NAMCOR Trading procured, bought, purchased
Yes.
assets?
Yes,
Is that correct?
that's what I understand here.
Okay. Then paragraph number 2, can you read it?
NAMCOR Trading and Enercon agreed to cancel
You were too fast.
Okay. NAMCOR Trading and Enercon agreed to cancel the asset purchase agreement signed between the parties and for Enercon to reimburse NAMCOR Trading a sum of 53,212,000 Namibia dollar plus interest of 7,411,456,000.07 cents as a once-off payment. The full sum of Namibia dollar 53,212 Namibia dollar plus interest in the sum of 7,211,456.07 cents, free from set-off or deduction, shall be transferred into the following nominated bank account of NAMCOR Trading.
Just hold on there. Now, you said by the 13th of September, when Mr. Ndeunyema is writing to Victor Malima, you are no more, you have nothing more to do with Enercon. Now, but when you left, was that agreement cancelled? The purchase agreement between NAMCOR Trading and Distribution and Enercon, was it cancelled?
Not that I remember, sir. No,
I'm asking,
it
was
wasn't.
it cancelled or
No.
not? Yes. Now, this agreement being referred to in paragraph 2, where it says NAMCOR Trading and Enercon agreed to cancel. Were you part of that cancellation, or did it happen after you left?
No, it happened after I left.
Okay. Now, just for interest sake, if the parties at a later stage agreed to cancel the agreement, do you know why we are in court today? And regulate what should happen to the money?
I don't know.
Okay. Can you read out under paragraph 3 the account numbers so that we move to the next page?
Holder, NAMCOR Petroleum Trading and Distribution Pty Limited, Bank, Standard Bank Namibia Limited, branch, it's the number 087373, account number 241039266.
Okay. Now, and the next sentence?
Just getting it to it there.
At page 189?
The payment set out under clause 4 above shall be made no later than 7 days from date of this letter. We look forward to your positive consideration. Sincerely yours, Shiwana Ndeunyema, Acting Managing Director.
Okay. As far as you are concerned, you spoke about you didn't have intention to run away. You have heard about investigation since which year did you say you had investigation of this case? But you remained in Namibia? In the morning you spoke about that?
Yeah, since 2022, 2023, we are hearing this.
Okay, now
Hearing this. Sorry.
it appears then in the meantime there is this engagement between the party to cancel the agreement. Today we are being told is a fraudulent agreement. Now, were you briefed by NAMCOR, by ACC or Enercon about this cancellation?
No, no, sir.
Okay. Now, let's assume Enercon as a company didn't honor the next page, the obligation to repay after cancellation. Were you in any way here or there, were you involved in such a breach?
No, sir.
Contractual breach, I mean.
No, not at all.
But even if you were involved, would that have been a breach of contract or commission of a crime?
No, it's a commercial transaction.
Sure. This country. Okay. Now, yes.
And it's only dealt with by means of civil proceedings. And
Okay. Now, let's then come to something else which shows that there is a total confusion and manipulation of these proceedings by the state and NAMCOR. Go to page 17.
I'm here, sir.
Now, there is what is second amended particulars of claim.
Yes.
You see that?
Yes, sir.
And if you look, Your Worship, that first document ran from 17 to page 30, Your Worship, for your notes. Your Worship, may I, for sequence, I made a mistake. I thought the latest document is the one at page 31, but I think the latest is the one at page 17. Let's start with the one at page 31, Your Worship. Sorry.
31.
Yes. Your Worship, just for your note, the one that starts at page 17 is titled Second Amended Particulars of Claim. Therefore, it's different from the one that started page 31 because that is amended particulars of claim. May I start with 31, Your Worship?
We can proceed.
Yeah, Mr. Elindi, page 31, please.
Yes, I'm here.
Yes. Now, if you look, go to page 43.
Yes.
That is what NAMCOR. Oh my God! This is even a different company that is having its legal noses all over now. You see, the first plaintiff is National Petroleum Corporation at page 31. You see that?
Yes.
That is not the company that entered into the purchase agreement with Enercon then in 2022.
No, not at all.
Okay, the one that entered into is a private company under paragraph 3, NAMCOR Trading Distribution, Pty Limited.
Yes.
Okay, fine, but let's see what they are looking for. In April 2024, what is the date at page 43 when they went to the High Court in civil court?
Which point?
What is the date at the bottom, page 43?
11th day of April 2024.
Your Worship, you see next page, page 44 is the signature of NAMCOR's legal representative who signed the commercial civil summons. You see that? So that is the date, on the 11th of April.
Yes.
Okay, what are they looking for in the court, our neighboring court, High Court here? Can you read out paragraph 1, 2, 3, and 4 for the record?
Page 43, right?
Yeah, that is what is
Yes.
these two NAMCOR companies?
The plaintiff claims an order declaring the asset purchase agreement between the second plaintiff and the first defendant to be null and void ab initio.
Okay, so that is what they are seeking for in the High Court, that the agreement of 2022 is declared null and void ab initio.
Yes.
And that is what's happening on the 11th day of April 2024.
Yes, sir.
But now, if you look at that, go back to page 188. 188, are you there?
Yes.
Paragraph 2. Is that not the agreement they said they cancelled? Mr. Ndeunyema already cancelled with Enercon in 2023 in September.
Yes, sir.
So in other words, it was cancelled by agreement.
Yes.
Do you know why? Many months after the agreement was cancelled, their going to court in a civil court, asking the court to declare it null and void. Do you know why?
I wouldn't make sense of it.
Does it make sense anyway?
Not at all.
Now, then go to paragraph 2.
An order declaring that the second, third, and fourth defendants.
Okay, let's just to assist the court. Who is the first defendant? Go back to page 31. Keep your one finger at page 43 and another one at page 31. Who is the first defendant? Second defendant.
Second defendant.
Keep
second
your
defendant,
fingers.
yes. First, second plaintiff NAMCOR Trading. Second defendant James Vilhoawala.
At number 6.
At
That
number
is page,
6,
yes,
yes.
that is the second defendant.
Yes.
And if you go back to page 43, they are saying an order declaring that the second, that is the second defendant, that is James Awara. And then, who is the third defendant? Go back to page 31.
Third defendant is Peter Elago Elindi.
Okay. Then they are saying, if you go to page 43, fourth defendant. Who is fourth defendant? If you go to page 32, Your Worship.
Then
Who is the fourth defendant at page 32, paragraph 8?
32. The fourth defendant is Malakia Elindi.
Okay. Go back then to page 43.
Yes.
They are saying, can you read out the full order now that the court is following? Who is the second, third, and fourth defendant?
I read the number 1.
You read number 2.
An order declaring that the second, third, and fourth defendants were knowingly parties to the carrying on of the business of the first defendant.
That is Enercon, fine.
In a fraudulent and or reckless manner, and that they are held personally liable for the debts of the first defendant.
Okay, so now, in that court, then General James Awara, yourself, and Malakia, they are saying you must be held personal liable for the debts of the first defendant. Who is the first defendant again? If you go to page 31, paragraph 5.
It should be National Petroleum Corporation.
No. Paragraph 5. Just listen to me before you answer. Page 31, paragraph 5.
Enercon Namibia proprietary limited.
Okay. So now the debts of the first defendant are the debts of Enercon then.
Yes.
Okay. Then go to page 43. What are they looking for in the civil court? Paragraph 3. Read it out.
Payment of the amount of Namibia dollar 53,212,000 Namibia dollar, together with interest thereon, at the rate of 20% per annum from 19 July 2022 to the date of final payment, jointly and severally, the one paying the others, to be absolved against the defendant.
Okay. That is the same amount. Is that the same amount? Are you tired? Are you tired? You are 60 years old.
But I can hold on.
Is that fine?
Yes.
Okay. Now, you're saying in the High Court that is what is being sought against you, Awara, and another Elindi. Now, is that the same? Just a question. Go to page 188.
Yes.
If you look at paragraph 2, is that the same amount they agreed with Enercon? Mr. Ndeunyema, Shinana Ndeunyema agreed with Enercon to cancel the agreement and Enercon to pay in September 2023. Is that the same amount?
Yes, sir.
Do you know why after that you are not only in the civil court where they are saying you must pay, but you are also now in a criminal court when there was even an agreement compromising NAMCOR's right? Do you know why?
I don't know.
Then, those are the orders, of course, Your Worship. The next one, what is the order number 4 at page 43?
Cost of suit.
Okay, they are seeking cost against you. Let's then go to another amendment to the particulars of case. This case keeps changing, being mutilated by amendment, a series of amendments. Paragraph page 17, go to page 17.
Yes, on page 17. At page 17.
Yes. So again, NAMCOR, which has nothing to do with the agreement, is the first plaintiff at page 17. Is that correct?
Yes, sir.
And the parties are there. Go to page 18. Who are the 9th, 10th, 11th, 12th, and 13th defendant? Say them one by one.
The 9th defendant is Immanuel Mulunga.
No. That is paragraph 9.
Yeah, that's paragraph 9.
You said the 9th defendant is
No,
fifth.
no. Paragraph 9. The 5th defendant
Yes.
is Immanuel Mulunga, an adult male.
No. Just
Okay.
end there. Go to paragraph number 10.
Number 10. The 6th defendant is Jennifer Hamukwaya.
Paragraph 11.
The 7th defendant is Cornelius Willemse.
Paragraph 12.
8th defendant, Olivia Dunaiski.
Paragraph 13. Who is the 9th defendant?
Is Davis Maposa.
Who is this David Maposa? Do you know him?
I don't know him.
Okay. Is he part of the accused person? I'm just asking.
No.
Okay. But let's talk about his credentials. Read out the whole paragraph 13.
Is David Maposa an adult male previously employed by the first plaintiff in the position of retail manager?
Yes.
Residing at number 5 Roosvarts Street, Eros Park, Windhoek, Republic of Namibia. The 9th defendant presently provides services to the first and second plaintiff in the capacity of a consultant.
Okay, fine. Go to then paragraph 21 to go to the crux of this matter. Page 21, paragraph 20. Can you just read it out? Paragraph is 20, Your Worship. Page is 21. Paragraph 20, page 21. Read out slowly.
On page 20, section 20 say, on 8th July 2022, the 5th defendant...
Just hang on there. Earlier you said the 5th defendant is Mr. Mulunga.
Yes.
Just, I'm not leading, Your Worship.
Yeah.
Go on.
The 5th defendant, in the execution of his duties pursuant to this contract of employment with the first plaintiff, purportedly approved a recommendation made by the 8th defendant.
And the 8th defendant, just so that the court is following, the 8th defendant is Olivia Dunaiski. Yes?
Yeah, and supported by the 9th defendant.
And the 9th defendant is David Maposa. Yes?
For the second plaintiff to acquire the asset, pumps, canopy, and tanks, and related equipment, the assets purportedly belonging to the fifth defendant.
Okay. I want to ask you, remember, you earlier testified about the 8th of July being the date that Mr. Mulunga made an offer to Enercon. You remember you testified about that.
Yes.
But here, there are recommendations within NAMCOR being spoken about. Were you privy to this? Is it your business?
No.
Internal recommendation, who recommend to who?
No.
Did you even know about this recommendation?
Not at all.
Were you part of them?
No.
Did you instigate or abet anybody to do it? If it is wrong, we don't know whether it's wrong.
No.
Do you have any reason to know that anything was wrong, anything was criminal?
No.
Do you have any evidence that Mr. Mulunga and them were committing an offense? Do you know?
No.
Then go to paragraph 21, your worship, at page 2022. And this, your worship, I will ask the witness to be very slow. This is really the crux of it, to show that this is just trumped up charges, bogus charges. Can you just read 21, paragraph 21?
Section 21, the purported...
It's a paragraph you are...
Sorry, paragraph 21.
Mr. Elindi, you must always listen to me.
Okay.
Because the record say if there is an appeal, if you are saying paragraph, just maintain its paragraph.
Okay.
Yes, otherwise we'll be confused.
Okay.
Paragraph 21, can you read at page 20?
The purported recommendation by the 8th defendant and the purportedly supported by the 9th defendant and approved by the 5th defendant was sequel to a sham valuation carried out by a certain Mr. Shefeni and Mr. Ipanda of the second plaintiff's engineering and technical department.
Okay, just hang on there. Let's go to see who is the second plaintiff. Go back to page 17. Who is the second plaintiff?
Second plaintiff is NAMCOR Trading and Distribution Proprietary Limited.
Okay, go back to paragraph 21, page 22. You already read that.
Yes.
Just hang on. You already read that the purported recommendation made by the 8th and purportedly supported by the 9th and approved by the 5th was sequel to a sham valuation carried out by a certain Mr. Shefeni and Ipanda of the second plaintiff, engineering and technical department.
Who purportedly valued...
Hang on. Do you know who Mr. Shefeni is?
No.
When you were negotiating this agreement, did you work with Mr. Shefeni?
No, not at all.
Did you in any way have anything to do, if he has created for NAMCOR Trading and Distribution a sham valuation, did you work with him?
Not at all.
Okay. Do you know Mr. Ipanda?
No.
But have you ever been given this sham evaluation by ACC or anybody?
No, not at all.
Did anybody at NAMCOR, including Mr. Mulunga, the CEO or the managing director, or anybody, ever accuse you in respect of any criminality in relation to a sham valuation?
Not at all.
Do you work at the engineering department of this complainant, second plaintiff?
Not at all.
Okay, then can you then read?
Who purportedly valued the asset at 53,212,000 Namibia dollar. The valuation was a sham because...
Okay, just hang on. Now we know, go back to page 51, no, 63.
Yes, I'm here.
you already, for context is important, go read that paragraph, the third one, which start, we surely. That is a letter dated the 8th of June. Mr.
Oh, sorry.
You must first let your lawyer finish. On the 8th of July, 2022, Mr. Mulunga wrote to you, read out his third paragraph.
Okay. We surely hope the above offer is acceptable to Enercon Namibia Pty Limited, and we await your official acceptance hereof. Herewith attached find asset evaluation report for commercial installation at Namibia Defence Force by the NAMCOR Engineering Department.
Okay. Earlier you told the court, and you were very fair, that the NAMCOR, actually their own department, evaluated the asset, the right interest and title in the asset they wanted to buy themselves.
Yes, sir.
Okay, then let's then go back to page, these are not the information put up in a public, at page 22, paragraph 21, so that we continue with that context. You read already that the evaluation was a sham because, can you read the next paragraph, two paragraph?
Yes. 21.1 say both Mr. Shefeni and Mr. Aipanda were not duly registered with the Engineering Council of Namibia to carry out such evaluation.
Okay, just I mean, to evaluate assets like pumps and whatever, do you need to be an engineer, civil engineer? No, I'm just asking.
No.
But anyway, is it your business if they are not registered? If they send their people to register and they are not registered, is it your call?
No, not at all.
Were you involved in nomination of this not so well qualified Mr. Shefeni and Aipanda?
Not at all.
Okay, then go to 21.2. Read it out.
21.2 say they failed to have regard to depreciation and the remaining useful life of the asset and simply did the evaluation on the basis of the current replacement value, which was not appropriate for the circumstances.
Now, so it's very, very clear now. This is now, people that you were working with at NAMCOR until you ended your tenure as a director, did they ever raise this with you?
No.
That look, that sham evaluation we did on our own, we actually do not trust it.
Not at all.
But is it your problem if they did a bad job? Is it your problem?
Not my problem.
Did you commit an offense not to have assisted them to do a proper valuation if it is not proper?
Not at all.
But did you even have knowledge that these people didn't do a good job?
No, not at all.
Let me just ask, they are saying, why were you, only if you understand, why were you taken to court because, amongst other, because of a sham valuation when you say that you were not involved in it? Well, do you know why? Were you told?
I don't know. It would only be malice.
Okay, let's go to paragraph 22.
Yes.
Continue.
The purported recommendation by the 8th defendant and purported supported by the 9th defendant and approved by the 5th defendant also followed upon a project feasibility study by a certain Mr. Hashera, the financial analyst employed by the second plaintiff, and which was based on a discounted cash flow analysis. The DFC analysis was not appropriate in the circumstances because...
Okay, fine. Again, you have been charged with corruption, with fraud, money laundering. First of all, were you involved in the appointment of this Mr. Hashera, a financial analyst? Were you involved?
Not at all.
Did you work with him to come up with an inappropriate analysis?
No,
DFC, whatever that is.
no, no, sir.
Do you know why, whether it is in a civil court or in this court or wherever, do you know why you have to be accused?
No.
Because, okay, now, the next is the DFC analysis was not appropriate in the circumstances because, can you read the
Because the first defendant had fuel supply agreement with the Ministry of Defense of the Government of the Republic of Namibia, MOD, which was entered into on or about 15 September 2016 and was to endure for a period of 15 years. That is up to 2031 and was further renewable at the instance of either of the first defendant or the MOD at 3-month written notice prior to expiry.
Okay, they appear to have known. So what? Do you know what they are complaining of?
I don't know.
Okay, then 22.2.
The assets were encumbered in terms of the agreements between MOD and the fifth defendant.
Okay, let's see the fifth defendant. Who is the fifth defendant? Just hang on. At page 18. Paragraph 9. Read out the ninth. Who is the fifth defendant being referred to? Page 18, paragraph 9. Who is it? They are saying agreement between MOD and the fifth defendant. Who is the fifth?
The fifth defendant is Immanuel Mulunga, an adult male presently employed in the position of managing director of the first plaintiff.
Okay, fine. But now, do you know of the agreements between MOD and Mr. Mulunga, Ministry of Defense?
No.
I can tell you. Go paragraph page 23. Paragraph 22.3. Can you just read that? 23, Your Worship.
There was, sorry.
And remember, just for context, against this is reasons why the analysis was inappropriate, they say. You are reading 3 reasons given why the DFC, discounted cash flow analysis, was inappropriate. Those are the reasons. You are reading now the 3rd given reasons. Go in.
There was an agreement of exclusivity of supply of petroleum products. For example, gasoline, illuminating paraffin, jet fuel, liquefied petroleum, gas, lubricants, any chemical used as a mixture of otherwise as a fuel for combustion engine, and any substitute or replacement of any of such petroleum products between MOD and the fifth defendant.
And the fifth defendant, you said, is Mr. Mulunga.
Yes.
But now you know what they are trying to say here. Do you understand what is the complaint? They are asking 53 million from we in the next building in a commercial court. Do you know what they are trying to say here?
I don't know.
Now, I want to jump that and to go to paragraph 25 at the same page, Your Worship, 23. Can you read out?
Paragraph 25 says, on 18 July 2022, the fifth defendant, acting on behalf of second plaintiff and in the execution of his duty pursuant to his contract of employment with the first plaintiff, signed the asset purchase agreement between second plaintiff and first defendant, well knowing that.
Yes, 25.1.
The price indicated for the purchase of the asset of 53,212,000 exceed his level of authority.
Yeah, but the agreement that Enercon signed with NAMCOR, what does it say about Mr. Mulunga's authority?
Jury authorized.
That, was it your business to go and in cabinet and search out resolutions and so forth?
Not at all.
But let's assume he doesn't have authority. Do you know why it is a criminal matter as opposed to a disciplinary matter?
I don't know.
Okay, then 25.2.
He did not inform the board of directors, BOD, of plaintiffs of the purchase of the asset and or that the ownership of the asset and whether the asset could be sold by the first defendant to the second plaintiff was not established.
Okay, anyway, is it your business?
Not at all.
25.3.
There had not been compliance with the provision of the Finance and Administration Standard Operating Procedure which required that the head of department must prepare a request for the fixed assets to be acquired and had to submit a request to Procurement Management Unit, PMU, for recommendation and approval together with the motivation letter, including budget verification and supporting documentation.
Yes, now, again, were you in a position to see, was it your duty to demand compliance with internal procedures?
Not at all.
Were you even privy to the provisions of the so-called Finance and Administration Standard Operating Procedure?
Those are internal NAMCOR processes.
And lastly, 25.4, can you just read that?
No budget had been approved for the acquisition of asset of that value.
Okay, now, again, do you have anything to do with that?
Not at all.
Did you commit fraud or corruption or anything? Did you abet anybody to not follow internal procedures so that you get a gratification?
No.
Now, just to understand, this case, what is happening? You are a party, just for the record. It's a civil case, commercial court case. What is happening now with it?
Still ongoing.
Where? Which court?
At the High Court.
In the High Court?
Yes.
What is ongoing?
Yeah, it has not been finalized.
Or the civil case has not yet?
The civil case has not been finalized.
Okay. So now, so in other words, when did it commence? This date is the first date was it in 2020? Which year did it commence?
I think it was in 2024, to the
Okay.
best of my knowledge. I don't remember exactly.
So did you know why? What prompted NAMCOR and the state to shift, to abandon to shift from commercial remedy, civil case, then to come to criminal case where it is even more difficult for them? Do you know why?
I don't know. I can only assume it's malice.
Okay.
Okay, maybe before you proceed, Mr. Namanja, it's about 1600 hours. The court is, can we agree on a date? Counsels, can you consult?
We are enrolled for tomorrow. It's just the time. We can start at 9.
Yes. Counsels, any comment?
Worship, and while we are, before my colleagues speak so that they can just address the whole thing one, we should also get an update on how far the copying is.
How far there?
The copies are. I say so, Your Worship, because I don't know how far Mr. Namanja is, but it will assist some of us to consult with our clients, and this witness might be finishing soon and need to comment on those documents, but he can speak for himself. But we need to get an update of how far the copying is, as it pleases you, Your Worship.
Yes, Mr. Mulunga.
Thank you, Your Worship. Now, Your Worship, this morning we have alerted counsel for the accused persons or applicants in these proceedings that we needed to disclose the documents. But the predicament that we find ourselves in is that these copies, we cannot just give the clerks who are making copies the whole docket to make. Yes, indeed, some copies were made, but we are not sure of how far they have went, because we cannot just give the copies, the rest of the dockets, to them to make. As your worship is aware that this is a sensitive case, where we cannot just give documents to make. So if council wants us to commit to a time, yes, all right, I understand, your worship. So what I'm saying in short is that if we can be given time to disclose to them tomorrow. I know I said today we will disclose, but unfortunately we were hoping we'll be given an adjournment to finish that after lunch. And also with regard to the starting time for tomorrow, we are suggesting that if the court is so amenable that we at least start at 10, so that at least we attend to the documents and any other aspect that we need to attend to, so that we won't be able to ask again for adjournments in between the proceedings.
Counsel? Okay.
Your Worship, I've just been informed by my colleague Ms. Hinda that there are accused persons who were remanded at Windhoek Police Station, and our application is that in respect of those that were kept at Windhoek Police Station, that they are all to be remanded at the Windhoek Correctional Facility.
Now, is the accused who were remanded elsewhere apart from Windhoek Police?
Accused 9.
Accused 9.
And I think accused 3 and 4, I'm informed, were Klein Windhoek Police Station. So all of them to be remanded at the Windhoek Correctional Facility.
Counsel, any comment on?
Yeah, may I proceed, Your Worship?
You can proceed.
Two things. Yes, we have no objection with proceedings starting at 10 tomorrow. And this is because we do not want to be difficult and obstructive. While we are not happy with the manner in which the matter is being dealt with, we ought to have those documents. I think it's just fair that the state is given an opportunity to provide us with documents. That's one. Secondly, we are having difficulties when consulting clients, particularly because we are getting documents very late. So we need to visit the place irregular hours. I do not want to make it difficult for the court without hearing out the state, but I would want the court, like it does in many cases, to urge or direct the state to facilitate that whenever we need consultation, we are given untrammeled right and access to our clients, so that we put up an effective defense for case for our clients in this bail application. Other than that, we are ready to commence tomorrow at 10.
Any other comment from any other counsel?
Your Worship, in so far as my client is concerned, perhaps maybe, Your Worship, what is the reason behind the state's sudden request that she be relocated to a facility other than the facility where she is currently being held? Maybe some form of justification, so that we may apply ourselves to that justification, Your Worship.
Any other comment?
Your Worship, I'm in agreement with the submission made by Mr. Namanje, specifically in regard to the annexures to the charges, because when we received those annexures midnight on Sunday, no, after midnight on Sunday, we attempted to consult with our clients at Central Prison, but we were made to understand that without an appointment, we cannot have access to our client. And of course, that is in gross violation of their constitutional right to a fair trial in order to prepare for the present bail application. So, number one, if an order may be made to ensure that counsel for the accused person be, of course, this is in terms of Article 12 of the Constitution, be permitted to consult with their client without any obstruction. And then number two, that any copies which they intend to use, that we get those copies on time in order for us to consult the accused person, because those copies are not meant for lawyers. They are meant for the accused person. Other than that, I am available to continue on behalf of first, third, and the eighth accused person tomorrow morning at 10 o'clock. Please, the court, Your Worship.
Your Worship, I beg leave to approach my client on this specific aspect of the transfer. I'll be brief. As it pleases you, I'm indebted.
May I respectfully ask that the accused person be seated while...
Your Worship, in respect of... Thank you.
Chief, with regard to...
She was not finished. Yes.
Oh, pardon.
Thank you, Your Worship. I'm indebted to the court. With regard to the transfer to the correctional facility in Windhoek, my client has no objection to that. We also have no objection to the commencement time being at 10 o'clock tomorrow. As it pleases you, Your Worship.
Yes, Your Worship, I've taken instruction from accused number 3, who is being kept at the Windhoek police station, where ordinary female inmates are kept. And of course, for the past few days, family members, friends, they've been visiting and taking food, clothing, and so on. And she would prefer to stay where she is right now, together with the accused number 4. Please, the court, Your Worship.
Mr. Lilongwe.
3 things or more. Firstly, we do not have the authority to decide when counsel for the accused person consult them. That is totally out of our control. That is something counsel for the accused person have to arrange with the prison officials there when they want to consult with them. With regard to the client of Mr. Bangamavo, saying she prefers to be kept at Plain Windhoek Police Station. Your Worship, it's not a matter of preference where an accused person wants to be kept. But we make that application cognizant of the fact that the security or the manner in which an accused person is kept at the police station is not the same as the correctional facility. And this is a serious case. That's why we, even on the first appearance, an application was made for them to be kept at the correctional facility. It's as a result of security there that the accused persons are more secure. The risk of abscondment at the correctional facility is less. Other than that, the documents will disclose to them at 8 o'clock tomorrow morning. Those documents will be ready. They will be available to counsel. Those will be our submissions in short, Your Worship. Mr. Court, please.
Your Worship, insofar as my client is concerned, may I then be made to understand, is the state suggesting that there is some security concern? has any threat been made to the accused person's security, Your Worship? If yes, by who? And in what form and manner, Your Worship? But most pertinently, insofar as accused number 4 is concerned, Your Worship, there is an objection to the transfer. Particularly, Your Worship, due to the fact that there are inherent difficulties in accessing the central holding facility, Your Worship, for consultation purposes. Your Worship, you may be aware that the specific facility operates on certain hours, and there is no special dispensation for legal practitioners to see their clients after hours, Your Worship, in particular. So, Your Worship, this would amount to a serious frustration to our efforts in consultation and preparation in advancing this bail application, Your Worship. So, the state's request insofar as my client is concerned, Your Worship, is objected to. But may we then be informed about this sudden security risk that has prompted the state to bring about this application?
I see my name being called. The submissions made in respect of the other accused persons for accused number 7 apply. But I do acknowledge.
Accused number 7.
Yeah, the Lydia. Is it 7 or? Yeah, I think it's 7. Yeah. Oh, honestly, we prefer that the ladies remain at Plain Windhoek because we can go and complete our consultation now after hours. Something we cannot do at that place I worked many years ago. I know how difficult it is to see clients. So honestly, who would want to pose danger to our client, and who is saying that, and why? It's a state responsibility to ensure that people are not harmed.
May I address the court? As the prosecutor who initially handled the matter, the instructions that I received from the investigating officer after consulting the correctional officers was that all the accused persons were to be detained at Windhoek Correctional Facilities. Now, at that time, I was not aware that Windhoek Correctional Facilities also have facilities for female inmates. Hence, when they made first appearance, I proposed that the 3 female accused persons be detained at Windhoek Police Station. So the information that we have received from the investigating officer is that all the accused persons in this matter, all 9 of them, be detained at Windhoek Correctional Facilities. That includes the 3 females, and reasons they have cited, amongst others, is that there's lack of space at Windhoek Police Stations. Therefore, it's best if the accused persons be detained at Windhoek Correctional Facilities. Now, we're not trying to be difficult. We are just complying with the instructions of the police officers that will be handling this accused person to and from court. As the court pleases.
Wish for this to become a back and forth.
Yes, Councillor.
But, Your Worship, at the end of the day, you have to make this difficult decision. And as it is now, Your Worship, I don't think the state has said anything, apart from telling this court in uncertain terms initially about a purported security threat.
Also, as you have indicated, the back and forth.
Absolutely, Your
Worship.
Worship. But Your Worship, it is important that I raise this point. Your Worship, there has been no evidence tendered by the officer who is in charge at that Windhoek Police Station about space concerns. And they have been there for the past couple of days that they have remained in detention, Your Worship. At the very least, there should have been some form of evidence tendered by the officer who's in charge of the Klein Windhoek police station, insofar as space constraints are concerned, Your Worship. But there is no need, Your Worship, that the state should be talking in two tongues. In the one vein, it's security threats. In the other, it appears to be instructions from the investigating officer, Your Worship. Your Worship, we have raised our objections. We have informed this court about the difficulties rife in accused persons detained at the correctional facility, and we stand by those, Your Worship.
Yes, the court will deal with the first things first. It is common cause that the parties are agreed that the matter be rolled to tomorrow. That is for continuation of the bail application and to proceed at 10. So both parties, you are informed 10 means 10. We must keep our time. And on that aspect further, it is apparent that the state have made an application that all the accused in this matter be moved to Windhoek Correctional Services. It appears that there are different views from the Defense Counsel. Some have no issue with that. However, for accused 3, for accused, that is 7 and 4, it appears that there is an objection. Yes, including 3, that there's an objection, arguing that they prefer to be there where they are. It's not a matter of preference. The accused can always be moved around depending on where it appears that it is fit to do so. And it's not a question of about preference as to where you prefer to stay. The accused are in custody and they remain in custody. They are in the care of the state. Therefore, all the accused are to be moved to Windhoek Correctional Facilities. Say, accused, can you just rise at the back? Just rise for a minute. Say accused number, that is applicant. Now the accused number 5, but the first applicant in this bail application, you are still under oath. You are informed not to discuss the contents of your evidence with anyone else. All accused, you are to remain in custody. The matter is rolled to tomorrow. That is 15 July 2025. That is for continuation at 10 a.m. Yes. The court then adjourns.